People have a lot of strong opinions about tipping these days, but this video isn't going to be about when you should tip or how much you should be tipping. Instead, I'm going to be answering the question, what exactly does the law say about tips and gratuities under Ontario's Employment Standards Act? Before we dive in, remember, the ESA doesn't apply to every type of job. Be sure to watch our detailed video explaining which jobs fall outside its protections. Also, this video is for educational purposes only and does not constitute legal advice, and it is not intended to create a solicitor-client relationship. If you work in an industry where tipping is common, you may have encountered a few different arrangements, like the practice of every employee sharing tips, or each person keeping all of the tips that they generate, or situations where your employer shares in revenue received from tips. It's important to keep in mind that there are employment laws that create responsibilities on the employer and protect the rights of employees when it comes to tipping in Ontario. If an employer fires or otherwise retaliates against an employee for exercising their rights or asking for their rights to be complied with, then there can be financial and other consequences for the employer. My name is Ryan Keeney and I'm a lawyer in Ontario. Let's get into it. Tipping and other gratuities are regulated by Part 5.1 of the ESA, and that part includes sections 14.2 to 14.5 of the ESA. Since the wording of these sections can get a bit confusing, this video will explain each of these sections in simple terms, so anyone who is an employer or employee can easily understand the rules, assuming the job is in Ontario and the job is regulated by the ESA. Let's start with the legal definition of the phrase tips or other gratuities, as it is defined in the Employment Standards Act. The definition, found in subsection 1 of section 1 of the ESA, is multifaceted and covers a range of scenarios. Firstly, it includes any payment that a customer voluntarily makes or leaves for an employee in situations where it's reasonable to assume the customer intended for the employee to keep or share the payment with other employees. This is what we most commonly think of as a tip, a direct gratuity from a customer to a service provider. Secondly, the definition encompasses payments made voluntarily to an employer by a customer under circumstances where it's reasonable to believe the customer expected the payment to be given to an employee or divided among employees. This could apply to situations where tips are collected and distributed by the employer. Thirdly, it includes service charges or similar fees imposed by an employer on a customer, where it's reasonable to infer the customer assumed these would be passed on to employees. This part of the definition is particularly important as it covers service charges often added to bills in restaurants and hotels. And lastly, the definition leaves room for other types of payments to be included as they are prescribed by the law. However, it's important to note what is excluded from this definition. The law specifically states that certain prescribed payments and charges relating to payment methods or a portion of these charges do not fall under the umbrella of tips or other gratuities. Ontario Regulation 125/16, specifically related to tips and other gratuities, provides additional context and clarification to the definition of tips or other gratuities as outlined in the ESA. A key aspect of this regulation is its focus on credit card charges. It clarifies that when a customer leaves a tip via credit card, the portion of that tip taken as a service charge by the credit card company is not considered part of the tip or gratuity for the employee. This is important because it affects the net amount that the employee receives as a tip. Here's how it works. When a tip is given via credit card, the credit card company typically charges the employer a fee for processing this payment. According to the regulation, the tip amount that the employee is entitled to doesn't include this fee. To calculate the actual tip amount, the regulation provides a formula. You take the total amount of the tip and multiply it by either the percentage charged by the credit card company or 1.5%, whichever is greater. For example, if a customer leaves a $10 tip on a credit card and the credit card company charges a 2% processing fee, the fee amount would be 20 cents, 2% of $10. This fee is not part of the tip that the employee should receive. This regulation is significant because it ensures that the charges by credit card companies do not reduce the actual tip amount that employees are entitled to receive. It provides a clear method for employers to calculate the correct tip amount that should be passed on to their employees when tips are paid through credit card transactions. This ensures transparency and fairness in the handling of tips, especially in industries where electronic payments are prevalent. This detailed definition in the ESA is crucial for understanding what constitutes a tip or gratuity in the eyes of the law, and thereby helps in clarifying the rights and obligations related to such payments in the workplace. Moving on to Section 14.2 of the Employment Standards Act, we delve into the core rules about tips and gratuities. The essence of this section is quite straightforward. It's all about the rights of employees to keep their tips. In simple terms, it says that employers are not allowed to take tips from their employees. This includes any actions like withholding tips, making deductions from them, or forcing employees to hand them over, unless there's a specific legal allowance allowance for it. Moving on to the enforcement aspect, which is outlined in subsection 2 of section 14.2, there's a strong protective measure in place. If an employer does go against these rules and takes tips from their employees, the law treats this action very seriously. The money taken is considered a debt owed to the employee. Think of it as if the employer has withheld part of the employee's wages. This makes it easier for employees to legally claim back their tips, reinforcing the principle that tips are a personal earning that belongs to them. What this means for you as an employee in the service industry in Ontario is significant. You have a right to your tips, and there are legal structures in place to protect this right. As a lawyer, I see this as a critical aspect of ensuring fair treatment in workplaces where tipping is a standard part of the income. Remember, these provisions are specific to Ontario and apply to jobs governed by the Employment Standards Act. So if you're in such a position, it's important to be aware of these protections and know that the law is on your side when it comes to your hard-earned tips. Moving on to section 14.3 of the Employment Standards Act, this section introduces specific circumstances under which an employer can legally withhold or make deductions from an employee's tips or gratuities. Under subsection 1, it states that an employer is allowed to withhold or deduct from an employee's tips if there is a legal basis for doing so. This legal basis could be a statute, which is a law passed by either the Ontario or Canadian government, or a court order. In practical terms, this means that if there's a law or a court ruling that specifically requires or authorizes the employer to take a portion of an employee's tips, then the employer can do so legally. However, subsection 2 introduces an important exception to this rule. It specifies that the above allowance does not apply if the statute or court order requires the employer to pass on the withheld or deducted tips to a third party, and the employer fails to do so. For example, if a court orders wage garnishment for debt repayment and the employer is supposed to pass on the garnished amount from the employee's tips to a creditor, but the employer fails to do this, then the employer is not protected under subsection 1. This section is crucial because it outlines the limited circumstances under which an employer can legally interfere with an employee's tips or gratuities. It balances the need to comply with legal obligations while protecting the rights of employees to their earned tips, except in specific legally mandated situations. Moving on to section 14.4 of the Employment Standards Act, this section addresses the pooling and redistribution of tips or other gratuities in the workplace. Subsection 1 allows an employer to withhold or deduct tips from employees if these tips are being collected for the purpose of redistribution among the employees. This practice, commonly known as tip pooling, is a system where tips are collected together and then distributed among employees, often based on predetermined criteria such as hours worked or roles performed. However, subsection 2 introduces an important caveat. It states that employers are not allowed to redistribute a tip to certain employees as may be prescribed. This means that there are specific categories or types of employees who should not receive tips from the pool, as defined by the law. Subsection 3 further clarifies that generally, employers, directors, or shareholders of the company are not entitled to share in the tips that are redistributed among employees. The idea here is to ensure that tips go to the employees who are directly serving customers or involved in the service process, rather than to the higher-ups in the company who don't engage in these activities. There are exceptions to this general rule, as outlined in subsections 4 and 5. These exceptions allow sole proprietors, partners, directors, or shareholders to share in the tips if they regularly perform a substantial amount of work similar to that of the employees who are receiving the tips. This means that if these individuals are actively involved in the day-to-day service work and are not just overseeing the business, they can legally participate in the tip pool. These sections of the ESA provide a comprehensive framework for how tips can be pooled and distributed within a workplace. They aim to ensure fairness and transparency in the handling of tips, making sure that those who are directly involved in providing service are fairly compensated through the tips they earn. Moving on to section 14.5 of the Employment Standards Act, this section deals with the interaction between the Act and existing collective agreements, particularly in the context of the Protecting Employees Tips Act 2015. Subsection 1 addresses situations where a collective agreement, a negotiated agreement between employers and a group of employees, was already in effect when the Protecting Employees Tips Act 2015 came into force. If such a collective agreement has provisions about the treatment of employee tips or gratuities, and there's a conflict between these provisions and the new Act, the collective agreement's provisions will take precedence. This means that for the duration of that collective agreement, the rules about tips as agreed upon by the employers and employees will override the rules set out in the Act. Subsection 2 considers what happens when such a collective agreement expires. Even after the expiry of the agreement, if the provisions about tips and gratuities remain effective, they will continue to be followed until a new or renewed agreement is put in place. This provides a transitional period where the old rules will still apply. Finally, subsection 3 clarifies that for any collective agreement made or renewed after the Protecting Employees Tips Act 2015 came into force, the provisions of subsection 1 do not apply. This means that any new or renewed collective agreements will have to be in compliance with the Act from the outset, without the possibility of overriding its provisions regarding tips and gratuities. This section of the Act ensures that there is a smooth transition from the rules established in existing collective agreements to the rules set out in the Protecting Employees Tips Act 2015, respecting the agreements already in place at the time the Act was passed, while ensuring that future agreements align with the new legal standards. And that brings us to the end of our discussion on the legalities surrounding tips and gratuities under Ontario's Employment Standards Act. I hope this has been informative and has helped clarify some of the complexities surrounding this topic. Remember, as a worker in Ontario, understanding your rights is key to ensuring you are fairly compensated for your hard work. If you found this video helpful, please give it a thumbs up and consider subscribing to the channel for more legal insights and updates. I'm Ryan Keeney, and it's been a pleasure guiding you through these important legal aspects. Your support means a lot, and staying informed is crucial, so don't forget to hit the subscribe button and turn on notifications to stay updated on new content. Thank you for watching, and I look forward to bringing you more helpful legal content soon.